Please rise. The Justice of the Appellate Division, Supreme Court, first department. He, all persons having business with the Appellate Division are here. Be attended and shall be heard.
Please be seated. Good afternoon and welcome to the Appellate Division First Department. As I call the calendar of today's cases and ask each of you how much time you need, remember that we've read your briefs and we're familiar with the record. Remember also that generally concision and focus make for a more effective oral argument. Ask for the time you need, not the time you might want. For those of you who have not been here before, the white light will go on when you have 2 minutes left. When the red light goes on, you should finish up your thought and sit down. Of course, if the panel has further questions after the red light goes on, we will continue to ask them. When I call your case, please rise and tell me how much time you're requesting. People versus Dace. Submitted. Sanchez versus Colorado Associates. Four and 2 and 3. Watson v. Lampkin. Justice Scarpula is recused on Watson v. Lampkin, so Justice Singh will be vouched in on that case, and also will take that case, Watson v. Lampkin, out of order as our first case. So, Appellant. Five and 3 and 4. People versus Adam Field. 4 and 1 and 4. Did I miss Garcia? Oh, I did. Sorry. I'm sorry, I missed Garcia versus 13 West 38 LLC. Okay. How about the owner, cross appellants? Okay. Uplift. Okay. I'll give you 5 and 2. For the respondents, why don't we start with Bene Rialto? Okay. Okay. And finally? Okay. So we'll go 5 and 2 for the plaintiff, 3 and 1 for the owners, 5 and 2 for Uplift, 3, 3 and 3. Okay. W/M Children is submitted. Freedom Trust v. DB Structured Products. Okay, I'll give you 7 and 2 and 7. Freedom Trust v. HSBC Bank. 7, 2 and 7. Morales versus American United is submitted. We'll begin with Watson v. Lampkin. You may begin.
Good afternoon, Your Honors. May it please the Court, Christopher Ryan Clark from Ginsburg and Misk on behalf of the appellant. Your Honors, although there are a number of legal issues that we've raised in our brief, this appeal is focused squarely on the interpretation of the 1996 corporate deed between 101 West 136th Street Realty Corp. and Tajay Anderson. The trial court made two fundamental errors when it issued the judgment. One, they held that the corporate deed, and I'll refer to it as the corporate deed going forward, was not duly acknowledged.
Well, doesn't it omit a key component, which is that it should recite that Lillian has power or had power at that time to convey?
The part that was crossed out, Judge Moulton, was only with respect to the corporate seal. And under the Weinstein case, what is controlling in this particular instance is, does the deed substantially conform with Real Property Law 309? Real Property Law 309 looks to four factors to find out whether or not something is duly acknowledged. Was the signer personally appeared? The signer was known to the acknowledger, that the signer executed the document in capacity and acknowledged the signature.
And 309 also requires, with respect to the affidavit that has to be provided, that the person who's signing is signing with the authority of the board of directors of the corporation. Isn't that correct? Isn't that the part that was crossed out?
That is the part that was crossed out. And
Isn't that important?
Well, we have to take into context what exactly is this corporation. This is a family-owned, single-asset realty corporation.
Was she the president?
There's no evidence that's been submitted contrary to that fact.
But she signed something under oath that she was the president, right?
That's correct. Not only the
So she wasn't the president, and she didn't have the authority of the corporation because the corporation was already, the authority of the board of directors of the corporation, because the corporation had already been dissolved several years previously by the Secretary of State, right?
But as Your Honor knows, that you can wind up the affairs of the corporation well after the actual dissolution
Who was she to
date.
wind up the affairs of anything?
Well, it was a dissolved corporation for failure to pay taxes. That's correct. But they're under BCL 1005 and the related statutes. There is a winding up of the corporation that needs to take place.
Under whose authority did she wind up anything?
As an officer of the corporation, as the president.
What officer?
She's the president of the corporation.
Since when?
Your Honor, we took a deed 2 decades after this happened. We weren't party to the corporate governance of this particular entity, so we were.
So what's the basis then of saying, in fact, that she was an officer of the corporation and had the authority to execute the transfer and the deed?
Judge Singh, she appeared before a notary, and she attested that she was the president of the corporation. It was a notarized signature, and my client takes title 2 decades after the fact. We're entitled to, this is a recorded deed. And as a matter of fact, even if it wasn't duly acknowledged, remember, acknowledgement is only required for recordation of the deed. It's not whether or not the real estate transfer was effectuated or not.
But counsel, your client took title knowing that the estate had filed a motion to intervene, that the motion was granted, and that the estate's answer provided pertinent information about the dissolution of the corporation. And doesn't the sale include the transfer of the claims over to your client?
That's correct. There was a dispute at that point.
So there's no ignorance here, right?
Well, no. To the contrary, we can rely on a recorded deed. It was recorded like nearly 2 decades before we took.
So your position, as I understand it, what you're saying is that, in effect, the deed's valid as to subsequent bona fide purchasers, correct?
That's correct.
Okay, but doesn't that analysis turn on whether the deed is void or voidable? And if it's voidable, I think the case law is on your side on that issue.
Yes.
But if it's void, then is the analysis the same?
Well, at the end of the day, the analysis was incorrect by the trial court. You're correct.
No, but I'm asking you, if you're a bona fide purchaser,
Yes.
and if we were to find that the trial court is correct, that it's void, not voidable, then is your analysis, at that point, do you have an argument with respect to being a bona fide purchaser?
The BFP prong or analysis that the court engages in only comes into effect when you're dealing with a voidable deed. A void deed is different. A void deed is void ab initio. But in this situation, you take a look at the second department case that I cited in my reply brief, the Chong-Hu case, where it says that when you're talking about corporate authority to transfer real estate, the appropriate analysis is voidable, not a void deed. Now,
Thank you, counsel. You
Thank
have
you.
time in rebuttal.
Good afternoon. Good afternoon.
Good afternoon.
May it please the court.
Actually, counsel, I want you to start with where your adversary left off, because I think he's correct. If the deed is voidable, then maybe trial court was wrong. What's your view of the Second Department Sha-Chung case, and why do you believe that it's void ab initio as opposed to voidable?
Your Honor, counsel brought up Weinstein. Weinstein says that it's that the deed or the prenup was substantively, the acknowledgement substantively conformed. Galetta said, if you're missing a substantive phrase, it's out. In this case, as the judge pointed out, the whole thing was crossed off. The whole acknowledgement was crossed off.
Well, that's not fully accurate. Portions of it were crossed off.
Well, it was the seal, the part that says I am the president. And facts, Your Honor. Ross Lampkin was the owner of this building. He bought it in 1978, and he got a loan for an HPD loan to rehabilitate the building. Subsequently, he entered into a rent stabilization agreement. In both cases, he used his seal. He acknowledged he's the president. I'm the president. Here's my seal. This is, Your Honor, this case was decided by a trier of fact. Whether a court sits at a trier of fact or whether a jury finds a fact, they all go through the same exercise. And in this exercise, as the judge pointed out, the appellant purchased this property withdrawn. The purchaser purchased the interest from Audrey C. Watson in year 2013. Let's look at that transaction. Audrey C. Watson is an unsophisticated seller. Why? She didn't have an attorney. So what did the appellant do? He gave her an attorney. And so let's look at the principle, Your Honor, of this. Okay, so he bought it for $100,000. The price was $200,000. But you only get the other $100,000 if I win the case below. So theoretically, he didn't win below, so Audrey C. Watson doesn't get $100,000. This is a building across the street from Harlem Hospital.
Counsel, is the law that complicated here?
This is not that complicated, Your Honor, and it isn't that complicated. A deed is void if it's under false pretense or under fraud. And I looked at every decision, Your Honor. I went through in my car and looked at every decision. I'll just briefly, Your Honor. Weinstein, it was substantively conformed, and so the deed there was good. Bernfeld, yes, they're standing. You have to provide an accounting. Chung-Hu, facts matter. Transfer is good. In Chung-Hu, let's look at that case. In that case, the petitioner consented to the defendant, Ms. Liu, controlling the business. And Your Honor, just one last thing, and I know that my time is up. The appellant principal is Joe McConney. Joe McConney, as the record will reflect, has a history of going up to Harlem and taking buildings.
Sir,
The
those
trial-
aren't the issues.
Yeah,
of the
that's,
case.
thank you very much, counsel. We have your brief.
Thank you, Your Honor.
Very briefly, Your Honors. There's an important concession in the estate of Lillian Lampkin's brief. At point 5, they admit that Lillian Lampkin was the heir of Ross Lampkin and would have inherited everything, including all of the shares to the corporation. That's a
But what's that based on? I mean, that doesn't necessarily follow, right?
Well, Your Honor, you've got.
I mean, it sounds like it could happen, but
Well, what I'm saying is that the very party that would have been able to testify to that is now, in the estate capacity, admitting to such, to the authority. Now, the court also has to realize that, listen, if the acknowledgement wasn't correct, you end up with avoidable analysis.
But it's not a question of the acknowledgement not being correct. I mean, the question is, I believe, whether or not the transfer was done under false pretenses, and the argument seems to be that it was done under false pretenses because although she represents that she's the president of the corporation, there's nothing there to establish it, and it's struck out.
That's entirely illogical. You have the estate of the actual signatory here in opposition. Why? Because the estate is basically an arm of Vincent Lampkin. Vincent Lampkin took a fractional interest in this property back in 1997.
Counsel, what difference does that make? We have to go back to the problematic representation that was made here in the acknowledgement.
But
Ms. Lampkin represented that she was the president. She
Correct.
was not. She had no authorization from any board of directors because the corporation was dissolved. She transfers the property without authorization, without apparent authority, to her niece for what, $10?
That's nominal consideration, which is typically, indicated on a real estate transfer. But Your Honor, there's no evidence that says that she wasn't authorized. And even if that's the case, it's the burden of proof of the defense, the respondents, to show that they have a challenge to this deed. They shouldn't even be able to raise this defense because it's time barred and it shouldn't be considered. Thank you.
Thank you. Sanchez versus Colorado Associates.
Good afternoon, Your Honors.
Hold on a minute, Mr. Counsel.
Oh, I'm sorry.
I left my glasses.
No worries.
You want a full complement? Okay, now, counsel, thank you.
Thank you, Your Honor. Good afternoon. My name is John Shaw, and I represent the plaintiff appellant Sanchez. In a nutshell, respectfully, the lower court abused its discretion by granting renewal here and vacating its prior order, which granted summary judgment. Renewal.
Doesn't renewal mean that if a party was unable to get certain information through no fault of its own, and they finally have this information at some point in time, that they should be allowed to be able to convince the court that the initial ruling was possibly in error?
In very limited circumstances.
Right. So in this case, because of the delays or lack of cooperation in the defendant being able to get certain information, and then finally getting the information, including information as to where the accident actually happened based on the plaintiff's own, I think, workers' comp form that actually give the address, even though he got it all wrong in his deposition. But all that information, isn't that something that would make sense as to an issue of fact as to where this accident happened? Isn't that critical here?
Actually not, because that, first of all, would open the floodgates. Defendant.
Wait a second, floodgates, but isn't it true that the defendant here doesn't own the building that your client says in his workers' comp application that he got injured at?
Defendant owns the building where, at 235.
No, I would just like you to answer my question, then I'm happy to hear whatever you have to say.
Sure.
In his workers' comp claim, he says, I got hurt at this building on 75th Street. This defendant that you are suing doesn't own that building, correct?
It does not own the building.
So
on
you're saying to
75th.
us now that in the interest of justice, we shouldn't have this renewal when, in fact, if your client's workers' comp claim is correct, either the workers' comp claim is wrong and your client's getting workers' comp from the wrong party, or your client sued the wrong party in this lawsuit, right?
No, first of all, the client clearly sued the right party. He testified that he worked at 235.
So then how does he explain his workers' comp claim?
The complaint set forth in 2016 that he was injured at Colorado's premises at 235 West,
Is he
76th
not
Street.
getting workers' comp benefits based on his application that says that he got hurt at 75th Street and not 76th?
That is incorrect, Your Honor.
Did he not submit I saw the workers' comp documents, so he did not?
There were other workers' comp documents where it showed and that he was getting paid for the injury at the premises of Colorado Associates. That was an initial...
No, okay, so here, don't you see that there is a substantial issue as to who owns the premises that he was injured at?
Actually, not, because I understand what Your Honor's point is, but this was an accident that happened in 2014. We sued them in 2016, claiming the injury was here. The building manager or the agent who certified the answer said that they owned the premises.
Counsel, that doesn't get you anywhere. The affirmation says allegedly this is where the accident happened. So he did not concede that this is where the accident happened.
But even when we moved for summary judgment, Your Honor, in 2018, the defendant's lawyer in his opposition, putting aside that 4 years transpired, they could have subpoenaed S&E for records. They chose not to.
Why don't you hold that point for rebuttal? I know that's another thread in your
but-
brief. No, counsel, I'll let you go over. You have some time on rebuttal.
Okay, thank you.
You're welcome.
Good afternoon, Your Honors. May it please the Court. Jeffrey Van Etten, Perry Van Etten, Rosansky and Kuttner for Respondent, Colorado Associates. The simple facts here, Your Honor, are legal.
So wait, let me just start where your adversary. What took you so long to figure out that you didn't own the building, or this worker didn't get injured at the building that you own? Why is it for so many years of litigation you didn't investigate that?
At the time of the incident that took place, the building that Colorado owned was undergoing construction. Because they had no knowledge of the incident, and that's what was testified to by the managing agent, They sued
Right,
the
the lawsuit was
contractor.
brought several years later, right?
Right, but they
And there
sued that
wasn't-
contractor.
There was no incident report on the day of the accident.
We never got one, correct. We had no knowledge of one, so the only way to try to address that was to sue the contractor working at our building. That contractor did not produce any documents, did not produce witnesses, and after failing to adhere to 2 court orders to that, we got a judgment against them. So as the owner who hired somebody, we did not know if they hired a subcontractor. It subsequently became learned from getting records finally from the employer who could not be sued because of a workers' compensation bar. When records were finally from them, they said that it happened at 75th Street, not 76th Street, hence the renewal motion. And those are the new facts that Judge Rodriguez, to her credit, providently and rightfully exercised discretion and granted renewal. Because the fairness here is this accident, and again, we'll have to have a trial because of the rulings, but this accident didn't happen at that location. And now that we'll be able to prove it. At the time, they didn't have it, the employer didn't cooperate, they were...
Counsel, when the plaintiff testified at his EBT that he thought he was working at a hotel, should that have put you on notice to do further investigation?
Should that have put us on notice? I guess, you know, when you're talking to someone and you have things like this, where they have that, they didn't even give the full address. One of the points made was, he said that it happened at 76th Street. He never gave the address. He never could do it. It's a residential building, a hotel. I don't know if it was a hotel at that time. That's just a descriptive that he gave. Is that accurate or not? To some people, lay laborers, whether they identify something as a hotel or another building, that's a factual issue that no one really knew here or recognized. It was vague. I mean, if you look at that whole record, as we pointed out, it was a vague testimony, and no one had direct knowledge. To take one point, I don't think that encompasses an ability to say, oh, maybe it happened somewhere else at that time.
Can you address the issue of the noncompliance by Safeway for the request for information?
At that time, we were not...
Why you didn't pursue that?
At that time, we were not counsel of record, and we came in after the fact. Safeway just refused to do it and undertake to respond to authorizations, and I don't know exactly why. They are a separate company from the actual employer. S&E Bridge was the employer. Safeway is the administrator out in a different state. I would submit, plaintiff apparently didn't get the records. My predecessors didn't get the records from Safeway. That's manifest by the fact that they didn't know either and get the information with those employment records that showed plaintiff at 75th Street, not 76th Street.
Thank you, counsel.
Thank you.
In their opposition, they conceded, by counsel's own admission, their predecessor counsel, that defendant owned the building, my client, and the injury occurred at the subject site, 235 West 76th Street, and we never alleged in the C3 form, which often things are mistaken, we never said my client worked at the 75th Street site, respectfully, but they rely on an affidavit from a Mr. Ariza. First of all, it's a defective affidavit. They said that it was sworn in Bergen County, New Jersey, and the one who notarized it is a New York notary from Queens County. So that is defective on its face, and that's the person they rely on, Your Honor. Bergen County is not Thailand. They could have obtained an affidavit from him or spoke to him or took due diligence and subpoenaed him, which we all do in litigation. I mean, if you walk across the GW Bridge.
Allow me
I'm sorry, Your Honor.
to twist this a different way.
Sure.
So the plaintiff identified people who worked with him on that day, Oscar and Rylan, right? And have you come up with any proof, any evidence that those persons who were working with him were working at 76th Street? Because the Ariza affidavit indicates that the work records were for the plaintiff and Oscar and Raylan at West 75th Street
No, we have not, Your Honor.
on the day of the accident?
But as Your Honor knows, the fact that a plaintiff does not obtain even an affidavit in summary judgment of a coworker is not a basis for a denial of summary judgment. All this stuff came out post-note of issue. They had all this time. I mean, that would, again, with respect to floodgates, the best analogy is I'm the plaintiff, and I have this perfect case, which is not in any way saying that they even have a good defense here, but my client falls from a roof, an unprotected barricade on the roof.
Counsel, we know the facts.
No, I understand that, but I'm just making a
bring it
quick
to a close.
analogy very quickly.
Okay.
And the employer says that we messed up. But unfortunately, the plaintiff did not move in a timely fashion under Brill. He didn't know how the accident occurred because he fell, but there was a coworker. They didn't obtain that affidavit from the coworker, or the law firm, the prior law firm, didn't do due diligence to obtain something like that. And then plaintiff says, well, we now have a great summary judgment motion. Unfortunately, we violated Brill. The courts are consistent. Too bad, tough luck.
Well, that's the point. Brill, when the city had a great case because there was no prior written notice, our esteemed Court of Appeals felt they were forced to go to trial and they were going to win anyway, wasting judicial resources. But bear with me for a second, sir.
Sure.
So here, okay, they're not getting summary judgment out of the case. All they're getting here, and you're right, they didn't move for summary judgment. They're moving for renewal to say our opposition to your motion for summary judgment, for partial summary judgment on liability under 241. What's going on now is it could be an issue of fact. Doesn't mean you don't have a good case. The question is do you have the right defendant in this case? And that could be fair game for a jury trial.
The problem is, Your Honor, is that anytime you use law office failure as an excuse and the fact that there was not cooperation, then on almost any case where someone loses summary judgment, they somehow find something, whether it's relevant or not, and they say that's a basis for renewal, and that is not respectfully the standard. They have not come close.
Thank you, counsel. You make that point very well in your briefs. Thank you very much. We have
Thank you,
both of
Your
your
Honors.
briefs. Thank you.
30 seconds since you went over, Your Honor?
No.
Okay, thank you.
Garcia versus 13 West 38th.
Good afternoon, Your Honors. Ryan Isaac, may it please the court. I'd like to kind of take my argument in the sequence that the trial judge did as well. I think it's just easier. Let's talk about whether or not plaintiff is a protected worker. As you know, Labor Law 25 and 27 have specific standards.
Now, you acknowledge that Mr. Rivera paid the plaintiff in your papers,
Yes.
and that the plaintiff knew that. Why doesn't that show that he was not an employee of Uplift or of anybody else on the job site?
Well, because it's statutory and it's also in terms of the case law. So let me answer your question directly. 25 and 27 don't talk about employment and protection in terms that they would in scope of employment or outside the scope of employment, or even in terms of workers' compensation. The statute says that an employee or an employer is someone who is permitted or suffered to work at the premises.
But who's the employer here, sir? I mean, if the employer, I guess, would be an unauthorized employee who had no authority to hire his colleague from a different elevator company, come in and masquerade in an Uplift shirt on a Sunday when they were unauthorized to work by any of the other parties, go up there, pay him $200 or $300 cash. I'm trying to wrap my head around the employer. Is Mr. Rivera the subject of the statute and in this context, sir?
I don't think it matters. My position is it doesn't matter. Here's why, okay? If you look at the Sanitas decision from the Court of Appeals, the Court of Appeals was very clear. The owner in that case said, There's no way in the world I can be liable because I have a lease provision with the lessee where he's not supposed to be doing the work at all. I have a right to stop it. He has to give it to me. The Court of Appeals said that that was irrelevant. And the reason that it did it, in my view, is it's a question of allocation of risk. Who should the risk be on? Should it be
Counsel,
on?
truly, you're not making very much sense. So if you have an employee who asks for permission to work on a Sunday and who's denied permission, right? And he brings somebody on board who he clothes in a T-shirt that belongs to the company, and they get into the building and they start doing work, and that man, the plaintiff, gets hurt. How can the company that said, do not work there, be liable? Isn't this like open and shut?
It isn't, and let me tell you why. Obviously, I don't think it's open and shut because I'm here. But the fact is that once Rivera has the right to be on the premises, vis-a-vis the plaintiff doesn't...
Back up. Who says he had the right to be on the premises?
Rivera...
He said he asked for permission and he was denied permission. He admitted that he didn't have permission from anyone at Uplift to have anyone work on the elevator, and he also, didn't he also ask for permission to work that weekend? Yeah, he was denied the request to work on that Sunday, in the record at 595 to 96, 614 to 15, and 663.
Correct. I'm not saying he's not. My argument isn't that. I'm not saying that Rivera got permission from Uplift to do the work. He said that he needed more time because they were rushing the job, and he needed more time to do it, and he actually asked for permission. He didn't get it. My point is that Rivera was the employee that Uplift chose to do the job. Vis-a-vis the plaintiff has no idea what any restrictions are relative to Rivera's employment. He's there doing work, according to his affidavit, which I don't see disputed at all.
So is it the proper defendant, Mr. Rivera?
Excuse me?
Is it Mr. Rivera the proper defendant?
No, my submission is that Rivera's employer, the employer or any responsible labor law defendant is the proper defendant, and...
How could that be? Did the plaintiff have any contact whatsoever with the employer?
No, he did not.
No. So there's no relationship at all with them. And he's an employee. He knows because he's employed that getting paid cash on the side is not the way that you work on a job, a big construction job, right?
Well,
so you're saying that we should that just because he had a friend who said, "Come do this to me," we should impute that to the employer who, one, told the employee Rivera no, and two, told him he couldn't go in, that we should impute the plaintiff, we should consider the plaintiff an employer under those circumstances? Can you imagine how that would open up the fight? Anybody who was in the building at that day could be called the employee, regardless of whether or not they were entitled to be there.
May I
Please
respond? I'm sorry,
Thank you.
I don't want to go over my time. So I understand the concern, except that was the exact argument that I believe the owner made in Sanitas.
No, it was a completely different thing. It was about a lease provision, which is a completely different. It was about the effect of a lease provision. It did not at all say that an employee is an employer is an employee of an employer who, in fact, doesn't have any. Rivera doesn't have any right to hire him. Didn't have any right to be at the building at that day. They're two completely different.
Judge Scarpullo, I'm not equating it for that. What I'm saying is that we're talking with. It seems to me that the panel has a problem. It seems like it's a pretty big problem with illegality, right? That was the work that wasn't.
It's that what the statute says. Because let's be clear, if he gets summary judgment, right? So if he gets summary judgment, at a minimum, he has to be an employee of the party, right?
He has to be an employee of someone, not of the party.
So maybe you could say he's an employee of Rivera, but there's no evidence that he was an employee of Uplift.
But Mordkovsky says not that it's employed by a specific entity, it's employed by someone. The term they used was someone, not necessarily the person that employed him, a point we made on page 36.
So you're saying if the custodian, if the sweeper hires me, and pays me cash, that the company is, anybody who works at that site can hire somebody else without the employer's knowledge or consent, and that in any of those circumstances, the labor law would apply to that person?
That's not what I'm saying. What I'm saying is that if a supervisor at the site, like Rivera was, goes to a third party and says, listen, I need help on this job, as between that innocent third party and the responsible labor law defense.
Where is the evidence that he's a supervisor?
He was the one doing the job.
No, he was a worker, but
Right,
he
but
clearly
he-
wasn't the supervisor of this job.
No, but he was the one doing the work. They
He was
charged
a
him with the
worker.
responsibility.
So
Right.
that is what I'm saying to you. You are saying to us, anytime anybody who works at a job hires somebody else for cash to come in and work on a weekend surreptitiously without the employer's knowledge or consent, that the employer should be held liable for strict liability.
I'm saying that in a allocation of loss situation, based on the cases and based specifically on the Sanitas case, yes, that allocation of loss goes to the responsible labor law defendant, not the innocent plaintiff who had no idea of any of these things.
Thank you, counsel.
Thank you.
Okay, we'll hear from the owner defendants next.
Good afternoon, Your Honor. Howard Fishman from Smith Major for 13 West, 38th, and NYC Management. Basically, believe that the court, Justice Armstrong, got the decision correct, that the plaintiff was an interloper. He was not permitted or suffered to work at the site. He was brought on by his friend to be there on a Sunday. The plaintiff had no reasonable expectations that he was authorized to be at the site.
There was some evidence in the record that this sort of casual hiring happens in this industry. And does that create an issue of triable fact concerning whether or not the plaintiff in this case was an employee of one of the named defendants?
No, because Mr. Rivera testified specifically that he knew that plaintiff knew that Mr. Rivera was paying him out of his own pocket and was not being reimbursed by Uplift. That doesn't create a question of fact as to that issue because there has to have been some relationship between Uplift and the plaintiff in order for there to be this employee relationship with them.
Does the passage of money between Mr. Rivera to the plaintiff necessarily mean that Uplift couldn't have been involved and just wanted to do it on the down low?
Well, if that was the case, then Uplift would have been grateful that plaintiff was there to help out, and that's not the case. Mr. Rivera was fired because of what he did, not ingratiated by his employer, Uplift, because of that.
Can I ask you, did plaintiff bring a Labor Law 200 claim against Uplift?
I don't know what the claim is against Uplift. I know that there was a 200 claim brought against my clients, Garcia.
I guess what I'm asking is, are all the claims that plaintiff brought dismissed?
All the labor law claims were dismissed based on the fact that plaintiff was not a labor law.
Even the Labor Law 200 claims against the person who installed the elevator thing?
Justice Armstrong dismissed plaintiff's complaint in its entirety based upon the fact that he found that plaintiff was a trespasser.
A trespasser, okay.
And even if he wasn't a trespasser, it's still not a Labor Law 240 case because it's not.
No, I'm not. I'm talking about a straight-up negligence claim.
Yeah.
You know.
So, we basically believe that the court got it right by dismissing plaintiff's complaint. In the event, however, this court disagrees, we believe that the court was also correct to award contractual indemnification against Uplift. For the reasons stated in our brief, we also believe that the court was incorrect in denying the motion against Benny by finding a question of fact. If there's a determination against Uplift, it's the same issue against Benny. In fact, it's even stronger because here we have a contract that's specifically executed between the two parties. It specifically provides for a start date of January 1st, 2000, whatever the date it was. It specifically provides that Benny's can provide insurance during the time of construction. There's no question of fact here. So we should have been awarded contractual indemnification against Benny as well as against Uplift, which we were.
Thank you, counsel. You have time in rebuttal, too. Okay, Uplift, I believe you're next. Please.
Good afternoon, Your Honors. Desiree Berger on behalf of Uplift Elevator. The lower court properly determined that plaintiff was a trespasser in this case.
Counsel, it's hard to understand.
I apologize. Let me take my mask off for you.
Thank you.
The lower court properly determined that plaintiff was a trespasser in this particular case. As the court has said, he had no permission, Rivera specifically had no permission from Uplift to hire or fire anyone. He was asked permission to work on a weekend and was denied authority to do so. He also asked for additional help and was denied authority to do so. He contacted plaintiff without the knowledge or permission of Uplift, offered to pay him cash, snuck him into the job site without Uplift ever being aware that any of this was occurring. I also like to point out for the court that there is a workers' comp decision dated December 14th, 2016, that's found on record page 1780, that determined that plaintiff is solely an employee of Rivera, which is, again, if plaintiff is seeking any form of redress, it should be against Rivera and not Uplift or frankly, any of the other defendants in this matter. If the court doesn't have any further questions about
I
plaintiff's...
just want to ask you about the Labor Law 200 claim, right? Your company, the Uplift is the one who installed the allegedly poor elevator, right?
Your Honor...
Whatever, the piece the lift that collapsed or didn't, or misfired, misfunctioned, correct?
We did install the elevator. However, there's been no evidence that it was defective or malfunctioned or was anything like that. This accident occurred when Rivera put the run box underneath his arm and triggered the up switch. The elevator moved up under power as it is designed to do. Rivera fully conceded that this is what happened, also that he had no permission to be there in the first place. So with respect to the Labor Law 200 claims and just common law general negligence, there can be no duty running from Uplift to plaintiff when they didn't even know that he existed, that he was there, that they didn't supervise, control, or direct his work because, again, they didn't even have a reasonable expectation that anyone at all would be there at the job site on a Sunday doing this kind of work.
Counsel, do you want to pivot to the contractual indemnification
Yes,
aspect
I would,
of the
Your Honor.
appeal?
Thank you very much. I would just like to highlight that the lower court improperly granted the owner-defendant's claims of contractual indemnity against Uplift. It's undisputed that the only time an indemnity clause is seen in this case is in a 2-month post-accident, one-sentence letter that is vague and imprecise and does not...
It's pretty specific. It talks about the actual date of the accident, doesn't it?
It does. However, it simply says that Uplift is to indemnify the owner-defendants without limitation. It does not have any saving language as required by the law.
You need the saving language when there's no evidence, as here, that the owner was negligent.
Your Honor, respectfully, that's an after-the-fact benefit. On its face, this letter simply violates the law, and it's unenforceable. There was no consideration. In fact, there's testimony from Uplift specifically that the only reason this letter was ever executed was because the owner-defendants refused to pay them for services.
That's Mr. Silverance's EBT?
Yes, Your Honor.
But that begs the question, why not just sue them to get the money that you're owed, rather than allow yourself to be held hostage in this way, as you put it?
Well, at this point, Your Honor, it's regardless of what they could or could not have done, the letter, as it stands, is unenforceable as a matter of law. It violates the GOL, and the lower court's decision that none of the defendants were liable is simply an after-the-fact benefit. The testimony plainly establishes that Uplift had no intention to enter into an indemnity agreement prior to this accident happening. The only contract that was in effect at the time of the accident was a proposal to modernize the elevator that contained absolutely no indemnity language. If the court has no further questions, I will rely on my brief.
Thank you.
Thank you.
You have some time for rebuttal.
Good afternoon, Your Honors, and may it please the Court. My name is George Epstein of Mead, Hecht, Conklin, and Gallagher, LLP. I'm humbled to appear before this Court today, and I appear on behalf of Respondent Fromark, Inc. Your Honors, I think irrespective of the issue about whether plaintiff was a volunteer or a trespasser, the Fromark's motion for summary judgment was properly granted by the trial court because plaintiff's accident had no relationship to gravity, was not caused by a violation of any industrial code provision, and was not caused by a violation of labor law section 200 by Fromark.
I wouldn't belabor the thing about gravity. I don't think that's a very good argument for you. What was Fromark's status? It was very unclear to me. I think the plaintiff says that the companies are all sort of they're incestuous, is what he says. Was Fromark the project manager, or was Mr. Katolik the project manager? Who was the project manager? Or actually, just tell me, what did Fromark do?
So, Judge, it's not entirely clear, and there's no denying that the incestuous mess existed, but if you look at the party statements that in the larger context of the record, you see that nothing that Fromark actually did involved any supervision or control over that actual work having to do with the elevator that caused the incident.
Okay, fair. What did it do, though? What was its mandate?
Prior to July...
And you can just characterize it. Was it a sub? Was it a general contractor? What did it do?
I mean, I guess you could call it a general contractor, but really they were just coordinating between the trades, So if there was an issue where someone working on the elevator needed help with an electrical issue, they would coordinate. Fromark might go and tell the electrical contractor that uplift needed something to do with the elevator. And so it was really just coordinating between the trades as opposed to actually being involved in any of the work that the trades were doing. And so there's some specific testimony that Mark Solomon gives on behalf of Fromark that I think addresses, how they interacted with uplift, if I can. So, on record excuse me, just a moment, I'm sorry.
Yeah, well, I don't think you even need to go down that path.
Sure.
There's some evidence that they hired Uplift. Mr. Solomon says no. He thinks that Catholic and Basin hired Uplift or brought them in, whatever that means. I don't know if this is that important, counsel. Why don't you wrap it up?
So I think it is important, but Mark Solomon testifies of record 1675. The question is, who, if anyone, if you know, supervised the elevator work? And the answer to that is, I would say that Uplift managed their own workflow. May I just finish this up?
Please.
They were a professional contractor, and I interacted with them, or Roosevelt Rangifo interacted with them, or John Cadillac interacted with them as needed, but nobody was daily watching what they did. So each of those other parties, they're representatives of the other parties, all they did was just interact with Uplift as needed to coordinate between the trades. But nobody was supervising their work. And if I can just make one more important point about the defects. The claimed defects are the speed of the elevator and the run box. The speed of the elevator and the run box were wholly within the scope of Uplift's contract. And when plaintiff arrived on site, he said that the elevator was only accessible by Rivera and Garcia. It had out-of-service sign on it, and that it was...
Counsel, that's all on the record. We understand. Thank you.
Thank you, Judge.
May it please the Court, my name is Michael Kazoris from the Law Office of Eric D. Feldman on behalf of the respondent, Benny Rialto. I'll be brief, Your Honors. Obviously, I adopt and incorporate by reference all of the co-defendants' arguments with respect to the plaintiff's claims. I do want to point out, additionally, as to the Labor Law 240 and 241 claims, that even though not addressed by the Supreme Court, Benny Rialto is also not a proper labor law defendant in that it was an out-of-possession tenant that did not hire any of the contractors at the site. Regarding the common law negligence and the 200 claims, as a out-of-possession tenant, my client also had no notice of the condition, actual or constructive, and did not create the condition. Now I'd like to turn my attention to the claim for contractual indemnity by the landlord.
Right. So you have this lease that once it was executed, the landlord is saying it was retroactively effective to January 1, 2014, and therefore covers the accident. So
Right.
we should respond.
Well, that's what they're saying, but the lease is to the contrary. As an initial matter, it's clear that the lease was not presented to my client until October 3rd, 2014, which is about 2 weeks after the accident. Also, paragraph 41 to the lease is entitled, "Lease not binding until executed." It says, in relevant part, "Submission by the owner of the within lease for execution by tenant shall confer no rights nor impose any obligations on either party unless and until both owner and tenant shall have executed this lease and duplicate originals thereof have been delivered to the respective parties."
Counsel, but paragraph 41 also states that the commencement date of the lease is January 1st of 2014. The expiration date was December 31st, 2023. And if you look at paragraph 40, it says that the terms and conditions of the lease shall remain in full force in effect except as altered by the terms of this lease. So yes, it's executed post-accident, but
Right, as altered by the terms of the lease, which
how
says
was it altered? There is no change here. There's no notations that have two sets of initials. Where's the change?
Well, paragraph 41 says it confers no rights unless and until it's executed, and that's also what the case law
counsel, but
is.
then once it's executed, you get all the rights, and the rights is to a commencement date that predates the accident. That's straight up contract interpretation.
I disagree, Your Honor, in the sense that I think this lease makes it clear that because the lease was not executed at that moment, as of January 1st, 2014, that provision doesn't apply in this case. In either way, there's an issue of fact as to when the lease was executed and when the obligations took place. So I don't think summary judgment would have been appropriate for the landlord, and the denial should be affirmed.
Thank you.
Good afternoon, Your Honors. Scott Taylor, Rosenbaum and Taylor for Respondent Just Renovation. In addition to what the other respondents have articulated, I just want to point out to the court that there's an additional point with respect to my client, and that it was merely a contractor, carpentry contractor that's sort of gotten caught up and lost within this litigation. But it had no supervisory role on this job site.
Mr. Katolik was the project manager?
Well, Mr. Katalik wore two different hats. He was a project manager for a company called NYC Management, which is not my client. And he was an employee of that company, and that was where he had his management capacity. But for Just Renovations, for which he's a principal, they did work such as drywall and wood framing and flooring, and had specific contractual obligations. It had no general contractor contract with anyone. It had no contract with Uplift, had no dealings with Uplift. It was merely a contractor, and again, it got caught up maybe because of Mr. Catal's role. I don't know the reason why, but Just Renovations, it's indisputed that it had no general contractor role on this job site.
I think some of it, the plaintiff makes a good point that Mr. Katolik's testimony was very hard to nail down concerning his role vis-a-vis your client and NYC.
Well, he was clear, but I mean, there's an incestuous, and this job site had a lot of that, which is, I think, one of the reasons why there were no written contracts between a lot of these parties, because there were pre-existing relationships, but confusion is not a reason to hold in a party that, you know, his testimony is relatively clear. It's just that, again, he had different hats. I mean, he said Just Renovations did this specific work, and nobody contradicted it. In fact, Mr. Besson testified that they did some, you know, when he was asked who was Just Renovations on this job, he said they did some carpentry work. Mr. Solomon for Fromax said that the supervisory role was Fromark's, not Just Renovation. I mean, there's nobody who said that Just Renovation had any dealings with Uplift, had any supervisory role on this job site. They merely did certain contractors' work, and that's not enough to hold anyone in under the labor law because they have to have the right to exercise control, which they didn't have.
Thank you, counsel.
Thank you, Your Honors.
Sorry, in the limited time I have, Judge Moulton, you asked a question about Fromac. They were GC by contract. It's page 8 of our brief, 1803 to 1804. As with respect to Mr. Cadillac, my only point would be that Solomon said he was actually the safety contractor, and his own test, he took out a permit as a GC. So for him to say that he's not a GC as a matter of law makes no sense. Judge Scarpula, I did want to read to you the Morkowski site because I know I might be swimming upstream here like a salmon, but this is exactly what the Court of Appeals said, and I'm quoting, "A plaintiff seeking the protections of the labor law, quote, must demonstrate that he or she..."
Say, I did read it. You don't have to read it out to me.
Believe me,
I've read it. I've read it more than once.
I'm sure you read it. But it said hired by someone, be it owner, contractor, or their agent. I think as a matter of fact, and as a matter...
I'm sorry, I don't mean to cut you off.
You can cut me off.
Where in this record, I hear what you're saying, where in this record was Mr. Rivera an agent for anybody?
He's an employee. I think by definition he's an agent, isn't he? He's an agent of his employer. Look, can I give you an example, Judge Shulman?
Sure.
Let me give you an example, okay? If someone comes to my office and has a dealing with my paralegal says to that person, listen, I'm going to do this, and I expressly forbid it. She's my agent. I might not have to give her...
No, in fact, she's not. In fact, all over the law is exactly who can be your agent and who cannot. And it is clear in many contexts who can be your agent and who can't. And just being an employee is not enough, in any context.
You're absolutely right. It's not what I'm saying. You can't create an agency by your own actions.
So
That's 100% right. But it's not just that agency. He's there, he's working, he worked with this person in the past, and...
Yeah, but he worked with this person in a different company.
100%, but...
In fact, the irony here is Mr. Rivera was really a helper, based on what I've read in the record, for the plaintiff.
Correct. He was an experienced...
And obviously, as a helper, he recognized that the plaintiff had a better skill set to help him get the job done because he couldn't get it done in time. Mm-hmm. So I understand the logic of what he did. The question is was he an agent for Uplift to do what he did? And it's clear that he didn't have actual parent or any kind of legally cognizable agency authority to do what he did. It was an off-the-book surreptitious maneuver.
Well,
and I'm trying to struggle to appreciate that you believe under these circumstances that everybody on the food chain here, from Uplift up and around, are on the hook based on his side deal with the plaintiff. I just can't.
Well, listen, I need your vote, so I've got a problem. But all I'm saying is if you look at the briefs and you look at the discussion, I'm sorry, Judge Moon, I shouldn't do, may I respond to the question?
Continue.
I'm sorry. That was the exact same claim that the owner made in the Sanitas case. I know you're saying it's different, but it's...
In other words, a tenant, if he met certain conditions under the lease, could bring somebody into the building to do work.
That's exactly...
Just bear with me.
Okay, I'm sorry.
The lease, the language, as my learned colleague pointed out, the lease provision would have allowed, if he got permission. So colorably, a tenant had that kind of power here in Sanitas. Here, Mr. Rivera had no power from any source to hire someone off books like the plaintiff to do the job here.
But that's my point, I'm sorry. The Sanitas owner, the argument was that the tenant had no right to do what was done.
He didn't do
100%.
it the right way. In
No,
other
he
words,
had no right.
The lease, no. The lease would have allowed the tenant under certain conditions to do the kind of thing. There was colorably the ability contractually for a tenant to do it in Sanitas. Colorably, I heard you. But here, there's nothing.
Well, but I could turn that argument around and say colorably, if Rivera had the right to do that, he could have. The point was that the work that was being done in the Sanitas case wasn't authorized, wasn't appropriate, and the owner's position was that it was completely improper. If I could just have 15 more seconds on the Labor Law 200 claim, I don't think trespasser status deals with common law negligence, right? We know that from Bassel, we know that from Skirty. To the extent that any of my adversaries are saying that this elevator wasn't effective, that's just not true. The building department specifically found that it didn't have an enabling switch. It was defective and it was running too quickly. So at the very least, with respect to uplift, since the trespasser status doesn't knock me out, I think if you provide a dangerous instrumentality at a site, that's not something that summary judgment should be granted on vis-a-vis the plaintiff with respect to the entity that actually provided it. And there is no dispute that Uplift did provide this, that no one had ever seen it, and that the New York City Building Department found it to be defective, took it out of service, and that the reason you had the enabling statute was to prevent this very type of accident, which was not intentional, it was unintentional.
Thank you. Counsel, you only have 1 minute. I would ask if you could focus on your claim against Uplift and your claim against Bene Rialto. I was going to do that, Your Honors. Just 2 points, one against Uplift. We believe that the indemnification provision does not violate GOL 5-322.1, the specific case law, Itchy Brick, which cites Hawthorne v. South Bronx Community Corp., a 1991 decision of the Court of Appeals, indicating that where there's no finding of negligence against an entity, the fact that the indemnification provision does not have a savings lounge does not make it defective. With respect to Benny, Benny had counsel involved in the preparation of the lease as well as, as my client did. If there was an issue as to the commencement date of the lease, it should have been corrected at the time it was signed, whenever it was, in November 2014. They signed a lease, it has a specific date commencement, it says it's several places in the lease, it's effective January 2014. There was no change to that. So we believe that it was effective at the date as the specific contract says. Thank you very much. Thank you.
Just briefly, in response to plaintiff's claims involving the run box and the elevator, the DOB violation was issued to the run box in the fact that it was lacking an enable switch. It was not defective in that the on switch operated exactly how it should have operated when Rivera put it under his armpit. In addition to that, the elevator, there's been no evidence that the elevator was oversped or undersped or was operating in any manner that it shouldn't have been. And in fact, Rivera and plaintiff had been operating it all day long up and down the shaft, wiring with absolutely no issues until Rivera put the run box, which is the controller for the elevator, under his armpit and triggered the up switch, which caused it to move under power and come into contact with the shaft. I'm just going to turn my attention briefly to the contractual indemnity claims of the owners. The lower court's conclusion that none of the defendants, including Uplift, owed a duty to plaintiff is an after-the-fact benefit when the agreement is still unenforceable as a matter of law. The simple fact is that the lower court's decision—
I'm sorry, it can only be unenforceable if you have evidence on this record that the owner could potentially be negligent. And that's what the case law talks about. You can't waive away or contract away your own negligence. But in this case, as everyone seems to be in agreement, except this side, there was no negligence of any kind on behalf of any of the owners, the agents, general contractors, the construction manager, property manager, and and et cetera, correct?
No, Your Honor. Actually, and it was in my reply brief in response to the owner's defendant's appeals as to the common law claims against Uplift. There is evidence that the owner defendants were negligent in this action.
Oh, by allowing him on?
Correct. The testimony establishes that no one, including Rivera, including Uplift, was supposed to be working at that job site on a Sunday, specifically because the Department of Buildings requires special permits for weekend work, which was not happening in this case. It's arguably, if the building defendants had maintained their non-delegable duty to keep the premises safe, to secure the job site, then plaintiff wouldn't have been able to sneak in and this accident would have never occurred. So, there is evidence that the owner defendants could be negligent in this case, and due to that reason alone, the contractual indemnity claims should not have been granted against Uplift. Thank you.
Thank you very much. Thank you all. People versus Adam Field.
Good afternoon, Your Honors. My name is Nancy Little, representing Appellant Adam Field. The SOAR court in this case found that Mr. Field was a level 2 risk. As we've set forth in our brief, in our reply brief, that was unsupported, given the numerous mitigating facts in this case, and really the minimal and unproven aggravating factors. But I think what the court also failed to consider was the impact that the level 2 adjudication would have on Mr. Field. Based on federal law, Mr. Field, who was in NYCHA housing, would be evicted as soon as the level 2 adjudication.
Isn't the concern, counsel, in a SOAR case or in a SOAR determination, what the impact of the defendant will be on the community and around children? In particular, here where you have someone who was in the possession of sadomasochistic images and videos of children who were allegedly tortured, stabbed, shot, and killed. Isn't the issue in a SOAR determination what the impact will be on the community and the kids?
Yes, Your Honor, but I think if you look at the full record in this case, that there's no argument that he presents a danger to the community. Both the federal probation and the federal court so found. And I think if you look at the prosecutor's brief, I don't want to speak for him, but they focus really on the risk of an online reoffense and not a community reoffense. There is no proof.
You're arguing the physical contact issue?
Right.
You're saying that because the defendant didn't actually commit the acts in any way, and there's no allegations that he had abusive physical contact with any children, that the fact that he was in possession of sadomasochistic pornography involving children. What was the youngest one? 3 months? The oldest one, 16 years or less, you're saying that that should be overlooked because that's mitigation?
I'm not saying it should be overlooked, but I think there's two things going on here. The first response is the people never showed that Mr. Field had any interest in sadomasochistic or snuff films. There were 5 videos out of the 570 videos that were on his cell phone that were so described. And I would argue without any evidence at all that he searched for those type of videos, that he asked for those type of videos, that he had any interest in that specific type of child pornography, then that is not actually a factor that aggravates his risk of reoffense.
Can't you imply that from the fact that he actually has that stuff on his 570 child pornography videos, and some of them are stuff, he didn't delete them as soon as he got them. He in fact traded them with other people, right? So, I mean, we don't have to have direct, that's pretty self-evident that if you keep it on your laptop and you keep it on your phone and you don't immediately delete it, it's pretty self-evident that that you want this stuff, right?
I would disagree. All we know is that someone sent him those videos.
And he didn't delete them, not for that day, not the next day, not 2 days after that. We're talking about 2 years, a couple of years, right? Didn't delete any of it.
Less than 1 year. But, you know, there are forensic examinations which would show whether he even opened that video. And I argue that when the prosecution fails to put that kind of forensic examination, which was done in federal court, in front of the SOAR court, they can't have met their burden by clear and convincing evidence of an aggravating factor. You know, they simply rely on numbers and types, but there has to be more than that for an aggravating factor. And I would argue that in this case, where, I apologize if I could just finish my sentence.
Please, finish the point.
In this case, where the psychosexual evaluation found that he had no pedophilic interests, that he had the interests of a normal male heterosexual, that he's been to therapy, that he's been in the community 2.5 years without any further problems, that he's learning how to cope with the underlying depression and isolation that sent him to the internet or sent him to the trading, that in that situation, and when he's going to be evicted from his home and sent
Thank you,
to
counsel.
the shelter system.
You do have some time in rebuttal, and also you still have some time on rebuttal.
Okay, thank you.
Very much.
May it please the court, Rafael Corbello for the people. Child pornography is not a victimless crime. What the defendant did here, it helps the pornographers because by consuming their product, he is, albeit remotely, exploiting these children as well. And as far as unproven aggravating impact or unproven aggravating effects, the prosecutor has the burden of proving the facts supporting the determination sought by clear and convincing evidence. That's Correction Law, Section 168-N sub 3. And the defense would have that statute rewritten to read, the prosecution shall bear the burden of proving the determination sought. What the prosecution has to do is show facts. How many videos, what were the nature of the videos, how long did he possess them, and whether or not that's enough of an aggravating circumstance is for the judge to determine. What the people have to prove by clear and convincing evidence are the facts. And the facts here show clearly that he is at minimum a level 2. The kind of folks who do the things that were depicted in those photos and videos, they're in prison. And if any of them should ever get out, they're a level 3. But here, defendant's a level 2, but because he possessed not only such a large number of material, but the nature of that material, there's no thesaurus in the world that can equip me with the proper vocabulary to describe the horror depicted in those videos.
Did the court adequately take into account his mental disability?
Yes, Your Honor. His developmental disability did not preclude him from understanding the wrongfulness of his conduct. He admitted that he knew what he was doing was wrong. And also the professionals who examined him drew the same conclusion, that he understands right from wrong. And so he knew what he was doing was wrong, and he admitted it to the agents when they showed up to arrest him. And as far as being evicted, defendants go at length to show that his sister Tabitha is a supportive presence in his life, that her strong support, both emotional and practical, of his sister Tabitha will stand the defendant in good stead. And that comes from defendant's brief, page 47. So there's no support for this notion that if he gets evicted, he's going to go straight to a homeless shelter. He has familial support. His sister is a grown adult. She's a teacher in a public school. So it's not clear that he's going to go straight from NYCHA housing to a homeless shelter. It's just not, hasn't been established. And if there are no further questions, I ask that the court affirm the decision below. Thank you.
Thank you.
Just briefly, we would never argue that those children are not victims or that those videos were horrendous. But we're asking the court not to punish Mr. Field again. Federal court did that. As to his cognitive impairment, it's true that it allowed him to recognize that what he was doing was wrong. But what it also, it's not severe enough that he also didn't recognize how to, with his therapy, improve it and move past it. And at the hearing, what I said was that if he's evicted, he's going to a homeless shelter. And that's the fact. He's not going to live with his sister and 2 children in Tarrytown. He is in a New York City probation supervision. And I don't think the court considered that. I don't think the court considered how his cognitive impairment and his severe speech impediment was going to impact him if he had to go to a homeless shelter because of the lifetime registration. And for that, since I think it would hinder his reentry, I think it does not help the community in this case to be told on the internet that he is a level 2, because he doesn't have a moderate risk of reoffending against any child in the neighborhood.
Thank you, Counsel.
Thank you.
Freedom Trust v. DB Structured Products. Please, Counsel.
May it please the court, Brendan DeMay, Holwell, Schuster, and Goldberg for the plaintiff. Freedom, the plaintiff here and in the original action, is a trust investor and has always held a beneficial interest in the trust. Freedom sued on behalf of the trust and now has received from the trustee authorization to sue on behalf of the trust. The trustee is empowered to authorize investor suits that are in the best interest of all investors and to dismiss suits that are not.
Except they argue, your opponent, that the no action clause bars this suit.
That's incorrect, Your Honor. The test is the authorization is permitted automatically unless the agreement specifically prohibits it. That is
but
what
the
every court...
PSA, let me just read
Yes.
chapter and verse. The PSA says, no certificate holder shall have any right by virtue of any provision of this agreement to institute any suit. So you talk about harmonizing the contract. Doesn't this harmonize? It says, ignore those other provisions. This is the one that counts.
Your Honor, DB admits on page 31 of its brief that that provision does not specifically prohibit the trustee from providing an authorization.
What are we doing here then?
I agree, Your Honor. What they
Counsel,
say is...
in other words, I think that's a slight overstatement of their argument, but please continue.
Their argument is that it prohibits it by implication. And every court to consider indistinguishable language has agreed unanimously that that language does not prohibit an authorization like the one here. It can be harmonized. Obviously, if the investor does not obtain the authorization and it shows up in court, then it's going to be barred. But if it obtains the authorization, then its right to sue is conferred by New York common law that empowers the trustee to authorize investors, not conferred by the agreement. That's what every single court to address this issue has held unanimously. Deutsche Bank does not cite one case, not one case that says an authorization like this.
Are all your cases DTCC cases?
No, Your Honor. That's one of their arguments, that all the cases are DTC.
All right, tell me about the ones that aren't DTCC cases, because I think those are distinguishable.
They both involve Wells Fargo, including one with Wells Fargo as a trustee. And if Wells Fargo can do it, Your Honor, HSBC can do it. Now, the other simple reason that requires reversal is the final sentence of Section 12.03. That's the enforcement provision. It contains an express list of who is empowered to dismiss investor suits.
But it doesn't say, it doesn't limit it to the certificate holder and the trustee. It just says it gives them the right. That's all. But it doesn't exclude other parties.
Under the Court of Appeals decision in Quadrant and the expressio unius canon discussed in that case, it does exclude DB. The trustee is on the list. Deutsche Bank is not. The parties are sophisticated, and that exclusion of Deutsche Bank from the clause must be deemed intentional.
Let me ask you this. Are you bringing this claim on behalf of all the certificate holders?
Yes, Your Honor.
And have you met all the conditions, the preconditions that would allow that? I mean, there are plenty of conditions. You can't just sue. Even assuming that the no action clause didn't mean what it says, which I think it does, but assuming that it doesn't mean what it says, did you meet the preconditions for bringing suit? Did you demand the trustee to do it and get a wrongful refusal? Did 25% of the certificate holders? There's a whole list of things. Which one do you fall into?
Those requirements do not apply if you get the trustee's express authorization.
That cannot possibly be. That just can't possibly be.
Yes, it can, Your Honor.
Tell me where it says that. Tell me where in the document it says that.
That's not the rule, Your Honor.
Read it. Just read it to me.
The Court of Appeals has
I'm
said
asking you, does that say it in the agreement?
it does not say
It
the
doesn't
trust,
say it at all in the agreement.
but that's not the test, Your Honor. The authorization is permitted automatically under New York contract law unless the agreement specifically prohibits
And
it.
here it specifically says otherwise, right? It says you cannot do it unless all these preconditions are met.
That's only if you're trying to sue without the trustee's authorization. If you get an authorization from the trustee, those conditions do not apply. That is what every single court to address an issue like this has held. If you don't get a trustee authorization, then yes, you need to satisfy each one of those criteria, and if you don't, then you're going to be barred. But if you do get the trustee's authorization, the claim may proceed.
Let's accept that it was a proper authorization. How do you get around this language? I don't know if it was quoted. If it was, forgive me for repeating it. No certificate holder, quote, shall have any right in any matter whatsoever by virtue of any provision of this agreement to enforce any right under this agreement except in the manner herein provided. So doesn't that work with my colleague posed to you that if he didn't meet all the different steps, which wasn't done here, wouldn't that defeat that clear language? Defeat the authorization that you claim would just supersede or skip over all that?
No, Your Honor. The key language is a right to sue by virtue of this agreement. We're not claiming a right to sue by virtue of this agreement. Our right to sue was conferred by New York contract law, which empowers the trustee in its
You mean the
discretion.
authorization, don't you mean the authorization and
Yes.
architecture of contract law? Okay, but the authorization invokes two sections of the PSA. It invokes 2.03 and 9.02. So it is through the PSA.
Every court to consider the question has held that that's not what is occurring. The right to sue is conferred by the granting party, not by the agreement itself. The granting party doesn't have to make the decision to grant authority to sue. So the right to sue is conferred.
But then, counsel, doesn't that vitiate all the rest of it that requires? Of course it does. It says even though we've all agreed to this, if the trustee decides otherwise, then none of this applies. That would essentially eviscerate the no action clause and all of the precursors to not having it, to not enforcing the no action clause.
That's incorrect, Your Honor. Every court to consider the question has said these can be reconciled.
Let me just say that, I mean, I've done this way longer than you have, and I don't agree with you that every court thinks that you're right and that this is the way we should apply it, okay?
The rule of law is that the provisions of the agreement must be reconciled if they can be. That is
Exactly, and what
Exactly.
you are saying to me is, let's not pay attention to any of the rest of the agreement and just say, once the trustee gives me permission to do this, all the rest of the agreement is vitiated.
That's not correct, Your Honor.
Counsel, you have a chance on rebuttal to respond to that. Thank you.
So I'm going to ask you straight up, why can't the trustee just give this certificate holder who may be, I think it's maybe 25% of the, whatever, it doesn't matter, give that certificate holder the right to bring suit?
Multiple reasons, but I think the most important one, Judge Capullo, is this court has said that the trustee can't. Now, Freedom Trust pretends that its arguments here involve a simple, well-settled application of New York contract law, and that the trial court's decision is somehow an anomaly. But it's actually just the opposite. The trial court's decision here was in conformity with literally 10 years of residential mortgage-backed securities jurisprudence by this court and rulings.
We were all marveling how 14, 15 years after the 2008 crisis and 2012, where most of the statute of limitations on these claims, and here we are in 2018, 19, and 20 with still new, fresh lawsuits.
And I think perhaps one of the many reasons Your Honor was grateful to be elevated to this court was that you didn't have to deal with them as a trial judge.
Counsel, at that pause, would you give us your appearance, too?
Oh, sure, I'm sorry.
No, it's okay.
William Russell, Simpson, Thatcher, and Bartlett, LLP, on behalf of Respondent DB Structured Products, Inc. As I was saying, Mr. DeMay's arguments fly in the face of multiple rulings by this court, construing clauses, no-action clauses, identical to 12.03 of the PSA that's at issue here, that hold that RMBS certificate holders, like Freedom Trust, can't assert claims for breaches of representation and warranties against sponsors like DB Structured Products here, and that the trustee can't waive 12.03, and that the trustee can't ratify claims asserted by the certificate holders in violation of 12.03, and that sponsors like DB are entitled to rely on the no-action clause in the defense of claims asserted by certificate holders like Freedom Trust.
Now, the plaintiff says that DB can't even properly invoke the no-action clause. Is that correct?
They argue that DB can't invoke the no-action clause, and their argument is one that's based on language that has been in all of the PSAs that were construed by this court that allowed sponsors like DB to rely on them. And it's the sentence at the end that says, basically that the certificate holders and the trustees and the trustee can assert rights against each other under this agreement. And all that means is that if the trustee, for example, breaches the obligation to bring a claim against the sponsor if certificate holders holding more than 25% of the interests directed to do so, or if one certificate holder takes an action to interfere with the rights of another, they can sue each other. That's all that sentence says. It doesn't say that the certificate holders or the trustee can simply ignore that provision if it doesn't happen to arise solely in the context of a suit among certificate holders or a suit between the trustee and certificate holders. It doesn't render that, but it doesn't read it out of the agreement. It simply says if one of these parties breaches, they can sue each other for it. And it's kind of telling that in 10 years of RMBS litigation, this is the first time involving identical provisions containing that sentence or words virtually identical to it, that this is the first time it's coming up. And I mean, this is why we have collateral estoppel and res judicata, because creative lawyers like my friend Mr. DeMay can always come up with nuanced arguments. So I think this argument is foreclosed by collateral estoppel because these claims were dismissed in the original action. I mean, which brings up an important point. I mean, we're here today because the trustee blew the statute of limitations. And the trial court dismissed the case. It was originally brought in 2013 on the grounds that in accordance with ACE and other decisions of this court, the trustee waited till more than 6 years after the securitization closed before bringing suit, apparently because it was not satisfied with the level of indemnity that Freedom Trust was offering it to bring the suit. We moved to dismiss, and the trial court granted the motion to dismiss on the basis that the trustee's claims are time barred and that the trustee could not take advantage of the earlier summons with notice filed by Freedom Trust because of 12.03, and that DB was entitled to rely on it, and that the trustee couldn't waive that provision or ratify the certificate holder's suit. And look, blowing a statute of limitations has consequences, and Freedom Trust actually recognizes that because, ironically, the next appeal you're about to hear is an appeal from the trial court's denial of a motion to dismiss brought by the trustee against Freedom Trust, where Freedom Trust is suing the trustee for blowing the statute of limitations. And, you know, that's one of this suit and that suit are just 2 of 4.
So I guess what you're saying is that the certificates holders are not remedyless.
Absolutely. Well, the 4 of you on this panel may decide whether they have a remedy or not. But you know, they recognize that what happened here is, for whatever reason, the trustee blew the statute of limitations, and they're suing the trustee for it. But it's important to remember that between Freedom Trust and the trustee, they brought 3 separate actions against DB Structured Products in this case. There's the breach of representation and warranty claims brought by the trustee that the trial court dismissed as time barred, in which this court affirmed. This court found, however, that certain claims by the trustee for breach of a purported obligation to notify the trustee breaches of warranties, that was a viable claim. So that case is still pending before.
Still bubbling along in the trial level.
Yes, that's still before the trial court. There's another 205A suit that was commenced the same day as this suit, not by the certificate holders, but by the trustee itself.
Right, the so-called trustee revival action.
Exactly. That case was dismissed in accordance with this court's decision and a decision that I argued this spring before the Court of Appeals, where the Court of Appeals affirmed that trustees can't take advantage of 205A in a case involving HSBC as trustee and an identical PSA. Nevertheless, the trustee, apparently at the direction of Freedom Trust, brought the 205A action. It was dismissed, and now they're appealing it to this court, despite the rulings of this court and the rulings of the Court of Appeals. My understanding is that a notice of appeal has been taken, but the Howell firm has not yet perfected that appeal. I see my time is up. Unless the court has other questions, I will sit down.
Thank you.
Thank you very much.
Counsel, just give us a moment. Yeah, it does keep you from... Council, just bear with us. We should be resuming shortly. Thank you very much for your forbearance.
I'm not going to wear the mask.
Okay, Council, thank you very much for your forbearance. You have 2 minutes of rebuttal.
Thank you. The first sentence of 1203 does not specifically prohibit authorizations, and the parties knew how to draft a clause that did, because they did later on in the agreement. Section 704 says the servicer shall not, the servicer, not the trustee, the servicer shall not authorize any other person to perform any of its duties. There's no language like that, an express anti-authorization provision that applies to the trustee. The parties knew how to draft one like that, and their failure to do so was intentional under the Schroen case. Next, Deutsche Bank has no authority to override the trustee's decision. In the enforcement provision, with respect, my friend on the other side did not accurately describe the language of the enforcement provision. It says, for the protection and enforcement of the provisions of this section, the trustee and certificate holders shall be entitled to relief. This section, the first sentence of this section, is the clause that they say prevents the suit. So only the trustee and holders may obtain relief may seek to dismiss a suit that violates that section. This clause is not just about holders suing each other. That's the second section of 1203. Deutsche Bank's argument is that when the enforcement provision says that it applies to the provisions of this section, what it really means is it applies to the second sentence, but not the first sentence of that provision, and it's not a credible reading of the enforcement provision. Since this court's decision in Ace, the Court of Appeals has taken 2 cases involving no action clauses. In both cases, the court has held the clause must be read narrowly and construed strictly, and the court has held that the clause does not apply. in particular in light of the expressio unius canon. That canon applies unambiguously here. Only the trustee and holders, not Deutsche Bank, who has the incentive to dismiss meritorious lawsuits and avoid responsibility for its misconduct. They do not have the authority to sue. Only the trustee does. And then only the trustee does and can authorize holders to. And finally, regarding the next appeal, this will be a nice segue. The next appeal illustrates perfectly why authorizations like this should be permitted and are permitted in every prior case. The cases should be heard on the merits. That's what the authorization does. It allows the case to be heard on the merits by the party who has the beneficial interest. When you don't allow authorizations, it just spawns a bunch of additional collateral litigation, blaming each other for who sued or didn't sue. The policy should be to have claims resolved on the merits, and that's what the authorization does.
Thank you, counsel.
Thank you.
Thank you both. Okay, finally, Freedom Trust versus HSBC. You may proceed, counsel.
Good afternoon. Lauren Eulig from Williams & Connolly for the appellant HSBC. The legislature enacted General Obligations Law 17-103 to strictly limit the ability of private parties to extend limitations in contract actions. The statute permits parties to effectively restart the applicable limitations period, or something shorter, as of the date of a promise to toll. But there are strict requirements for the statute, and any promise to toll that is inconsistent with 17-103 has no effect.
That's only if we're not applying Delaware law as the court below did. So do you want to start there?
So, yeah, sure, Your Honor. That's not correct. So 17-103 applies if you apply the Delaware statute of limitations.
No. It says, don't apply New York law in time issues, right? That's what the agreement says. So let's assume that we all think the agreement says what it means, and we're applying Delaware law. Under Delaware law, both its extensions of these agreements, tolling agreements, I couldn't think of the word, and its regular statute. Is this, if we apply both of those, this is a timely suit, correct?
Well, respectfully, Your Honor,
I just want to, first, respectfully, yes, okay, promise you want to hear everything you have to say, but I just want you to answer that first. If we apply only Delaware law, this is a timely action, correct?
No, that's not correct.
No? Okay, so tell me why not.
So as an initial matter, the conflicts of law provision does not say...
Again, I'm not talking about, I'm asking you, assuming that the agreement says what it means, that we are only applying Delaware law with respect to timeliness of the action, right? Or time bars, or I could look and see what
Just pretend we're in Delaware.
Yeah, let's pretend we're in Delaware. Is this suit timely under those statutes?
No, it's not.
Okay, tell me why.
It's not
under
timely.
Delaware law.
Under Delaware law, and I'm going to go back to the conflicts of law provision because it's important. So the conflicts of law provision provides that the construction and effect of the contract shall be governed by New York law. It's our position that includes New York law. I'm sorry, Your Honor, I'm going to continue.
I know you want to make your argument. I just want you to listen. I want you to make your argument, but you're seriously not answering my question. So that leads me to ask it again. Forget about conflicts of law. If we are in Delaware, is this timely under Delaware law?
No, because you would still need to apply New York substantive law to interpret the contract.
Even though the contract says not to do that?
It doesn't say not to do that. It says that New York law shall not be deemed to govern the law related to time-based offenses.
What do you think that means? You think it means something else? Then don't apply it?
Yes, I do. I think it means
So
that
then why would you enter into all these agreements knowing that they're not going to be effective?
I don't think anybody entered into this agreement assuming that it was ineffective.
So,
The
okay, so
parties did
now
think
you
it was
entered into
effective.
it, you had the other side rely on it, not to sue you, and now you're saying, oh, this agreement that I had my very experienced lawyers look at actually is ineffective.
That's the situation every single time that 17-103
No,
applies.
it's not at all. It's not at all every single time. But my question to you is, at the time you entered into this agreement, you thought that it wasn't going to be effective?
No, that's absolutely incorrect. I think both parties thought it would be effective.
Right, and so both parties, I guess, assume that when we shall deem this not to apply to timeliness issues, I guess both parties thought that that meant that we're not going to apply.
No, I don't think that's right, Your Honor. If you consider the contract as a whole, it does not place a choice of forum. So it leaves the parties open to choose what forum they want to file their lawsuit in. The initial part of paragraph 13 in the choice of law provision says that New York law shall govern.
Do you not agree that both parties assumed that these agreements would extend the statute of limitations at the time that that was both parties' understanding, correct?
I think that is correct,
Okay.
yes. I think that both parties thought it would extend the limitations period. Ultimately, it does not. The carve-out for time-based defenses says that New York law shall not be deemed to govern time-based defenses. What that means is New York law is not the presumptive law to apply if we are looking at time-based defenses.
Okay, is there any case that you have that would say that that means anything but what it sounds like and says?
If it didn't want to apply New York law, it would say New York law does not govern. And I don't even know if the contract could do that, because I think the law is unclear that parties can contract out of New York procedural law. I think the time-based defense carve-out applies to procedural law as an initial matter only, and New York General Obligations Law 17-103 isn't procedural law. It is substantive law. Barclays makes that clear. Bayridge makes that clear. So we have a situation.
Fair to say, speaking of 17-103, that this is maybe a matter of first impression. That successive tolling agreements haven't really come up before. I don't know why, but is that correct?
Yes, Your Honor, it is, I think, a matter of first impression. And I think it goes back to the unique situation that we're in, why it hasn't come up before. We have a claim that accrued purportedly as early as August 2012. The parties entered into an initial tolling agreement back in 2015 and then proceeded to amend it 12 times to the point where the tolling period in the agreement spanned 6 years and 2 months, which is longer than any potentially applicable limitations period and is therefore directly contravenes 17-103 on its face.
But isn't the focus, in looking at this, you have to make clear that when the tolling agreement first was initiated, that it was done timely. No debate about that, correct?
I'm sorry, I didn't hear you.
I'm sorry, we accept 3-year, Delaware's 3-year statute of limitations. The first tolling agreement, as you pointed out, was 2015, so it was timely, correct?
Correct, Your Honor.
Each agreement was within a segment, a 6-month segment. It wasn't an indefinite period.
It was not an indefinite period.
So that notwithstanding that you refer back to the original agreement, and I read you were counsel below who argued before Judge Cohn, correct?
Yes, I am.
So I read your argument with interest, but the point is your view is that original date controls all the way through, rendering it indefinite, which runs afoul of the GOL law, but in reality, each agreement itself was a unit in itself, correct? And that would render it timely.
So no, Your Honor, because the Court of Appeals in Bay Ridge made clear that promise in 17-103 means the beginning of the tolling period, not the agreement. The Court of Appeals in Bay Ridge was faced with a 1976 agreement where the parties agreed to toll for what would otherwise be the applicable limitations period, starting at a future date. And when the plaintiff brought suit, the plaintiff told the court the promise for 17-103 should be interpreted as the date of the 1976 agreement. And the Court of Appeals said, no, that's not right. The date of promise is the date of the beginning of the tolling period.
Thank you, counsel. You have time on rebuttal.
Thank you.
Good afternoon. David Kleban, Patterson, Belknap, Webb, and Tyler for the plaintiff respondent. The parties did something that Justice Cohen recognized as common. A cause of action accrued. They entered into a tolling period for a fixed indefinite period. As that period started to approach its end, the parties entered into another agreement for another fixed indefinite period, and they repeated that process several times over the course of the next several years. When all was said and done, they had began their tolling regime on May 20, 2015, and Freedom Trust sued HSBC on May 19, 2021, less than 6 years later.
I thought it was 6 years, 2 months, but this may not be important.
Is
there a public policy of repose that runs athwart your argument?
No, not one that's been expressed by the legislature, at least. The legislature is responsible for balancing the interests of repose and having suits heard on their merits. They imposed a requirement in Section 17103. They imposed that requirement on a promise. They identify a category of promise that parties might want to enter into, and they say what that promise must do in order to be effective. What they don't say is whether you can enter into multiple promises, or if there's some aggregate limit to the effect of the promises you can enter. They could have written that easily, as Justice Cohen recognized. Instead, what they chose to do is to make it so that you can't, with one fell swoop, enter into an agreement that might extend the period until who knows how long.
Which is what you could do in Delaware, correct?
Which is what you can do in Delaware. Other states have more liberal regimes when it comes to this. New York has a slightly more conservative regime, but what they don't do is they don't create an artificial limit on parties' ability to extend their tolling. And it's somewhat serendipitous that in the last case, we heard another Freedom Trust case. That's a case in which Freedom Trust is trying its best to recover on behalf of the underlying RMBS trust from the mistake that HSBC made that we're now suing in our personal capacity for. And there was
let me ask you, counsel, what do you think this means? Provided, however, that New York law shall not be deemed by operation of this agreement provision to govern the issue of which jurisdiction's law shall apply to any time-based defense. Why put that in? What do you think that the parties meant with that?
The parties were entering a tolling agreement, and the goal of the tolling agreement, you can look at how broadly they define time-based defenses.
Right.
They want to toll any conceivable statute of limitations. If Singapore happens to supply the statute of limitations, they're going to toll it. They are being agnostic in this agreement as to which body of law would supply the relevant limitations regime. And so they're saying, yeah, we'll take the benefit of New York's well-developed body of law to interpret this agreement, to give effect to its provisions. But what we're not doing is we're not electing to have New York General Obligations Law 17103 apply if Delaware's law would otherwise apply.
So let me ask you this. Did you wind up amending your complaint to assert that Delaware, that you are a Delaware corporation and Delaware law applies?
Well, actually, Your Honor, our position is that we were a New York resident.
Oh, I'm sorry, right, in New York, right. Did you amend your, I got it backwards.
That's right. We have amended the complaint to allege that we're a New York resident at the time the cause of the action, the time the cause accrued. And, under New York's 6-year limitations period, we're fine. Because I wanted, just in answer to Justice Moulton's point, we sued less than 6 years after the very first tolling agreement was entered. And so even if you want to count this as all one promise, we're in the time limit. But you shouldn't count it as all one promise. I think this is important. We need to recognize that the legislature meant what it said when it imposed requirements on a promise, but didn't choose to restrict the number of promises. And HSBC tries to frame this as one contract with multiple extensions. Now, first of all, that elevates form way above substance, but it's also wrong on the form. Each time the parties came together and did one of these agreements, they called it a new tolling agreement, an amended and restated tolling agreement. The preamble to each one, you can look at page 149 of the record, it defines itself as the tolling agreement. Each one has new signatures. Each one has its own representations and warranties. Each one has an integration clause. And each one says that there are mutual promises being exchanged. And that's the consideration for this new agreement, a new promise. And what does that new promise do? It creates something that the parties didn't have before, a new period, up to 6 months, but potentially less, during which Freedom Trust wouldn't sue without providing notice, and during which HSBC promised us that they wouldn't count that time against us when asserting any limitations defense. Is that illegal under the general obligations law? It is not. And we should leave it to the legislature to tell us if parties can't execute multiple tolling agreements. Now, they also tell us—
Let me just make clear, you're saying your first line of attack is that the GOL doesn't apply because of that carve-out for the time-based defenses. Is that correct or not correct?
Well, it's both, Your Honor. They're misreading the effect of the general obligations law, and they're also doing an inappropriate thing by trying to engraft their incorrect reading of the general obligations law onto what they say is the Delaware statute of limitations. Now, as I say, we don't think— we argued to Justice Cohen, and we maintain that Delaware's 3-year limitations period doesn't apply to us. But the effect of the tolling agreement is legal under New York law. And even if we were even if they wanted to mix and match and apply the Delaware statute of limitations along with the general obligations law, the law doesn't mean what they say it means. Because think about the effect. If parties can only enter into one agreement, and if, as HSBC says, once you enter into that agreement, you lose all the remaining time you had on the initial statute of limitations clock, well then, a party could have a breach of contract occur. They enter into a tolling agreement, say 6 months later. They agree to toll for a year. Under HSBC's interpretation, that's all they get. And when that year is over, they have to sue, and they don't get any of the time on the front end. That cannot be the law, and in fact, it's not the law. It's not what the legislature wrote. Thank you, Your Honor.
Counsel.
Thank you. To find that Freedom Trust is correct in its interpretation of its ability to have successive promises, this court would have to do 2 things. One, you would have to ignore a Court of Appeals precedent in the definition of promise. The Bayridge makes very clear the definition of promise is the beginning of the tolling period. It is not the date of the agreement. Second, this interpretation eviscerates 17-103. 17-103 was designed to create strict limits on the amount of time parties can toll. The legislature said as much when it created the statute. If you look at the history in 1961, it says parties should not be allowed to create periods between themselves that are greater than what the legislature has allowed. So to go forward and say that the parties can enter into successive promises indefinitely, it renders 17-103 completely meaningless, which can't be what the legislature intended. The legislature intended here was that parties would be limited to a very specific time period and ability to toll. And here we're faced with a single agreement, and I put forward in the brief a number of reasons why on its face it is very clearly a single agreement that has a very clearly stated promise from May 2015 to July 2021 that exceeds the limitations.
I have to tell you, counsel, that I'm listening to you, and I listened to you previously, and it just seems to me that you're making a gotcha argument. You know, your client was the beneficiary of successive tolling agreements, and at the point where the tables turned and it was time to, your adversary decided to sue you, your client said, gotcha, you can't sue me. And it just, I know you said that there was you indicated there was no bad faith here, but that doesn't seem how it appears. The language is so clear in the choice of law provision, I don't see how you can possibly get around it.
In terms of applying New York law through the choice of law provision, is that what Your Honor is saying?
I'm not going to answer your question. I think the comments of the bench have indicated how it just doesn't fly.
Okay, well, I see my time is up. Thank you.
Thank you, counsel.
Thank you.
Thank you both.